A very good evening to all of those who've joined us today for Text in Context with BananaIP September edition. Before we begin with the presentations lined up for today, I would like to wish you all a very happy Teachers' Day. And what better day than today to take out some time and understand and update yourself with some text, which would be either recent orders passed by courts in India and abroad, IP office notifications, or IP statistics from the last month, to which the associates at BananaIP would be providing some context. Also, if during the presentation you have some doubts, please feel free to drop messages on or comment on the LinkedIn Live, and we'll be monitoring those comments and we'll be happy to respond to them. And on that note, let's begin Text in Context with BananaIP. First up, we have Lavanya, who will be presenting on two recent Delhi High Court judgments on trademark and copyrights involving Sun Pharmaceuticals and Telegram, the app, respectively. Over to you, Lavanya.
Thank you, Kavya. Good evening, everyone present. So today I'll be taking up two recent updates for trademark and copyright. So first, let's proceed with the trademark updates. So this is a recent case decided by Delhi High Court on 26th of August, which was Sun Pharmaceutical Laboratories Limited versus Hetero Healthcare Limited. So the facts of the case were basically Sun Pharma had first applied for the mark Letros in 2001, but which were opposed by Novartis. So it was reapplied in 2010 with a user date of 2001, which was eventually registered in 2016. Whereas Hetero Healthcare had applied for the mark Letro under Class 5 in 2007 and was subsequently registered. Sun Pharma claimed that they have been using the trademark Letros for a generic drug for second-line treatment of advanced breast cancer. Now, the issue of the case was Sun Pharma claimed that the mark Letro was by Hetero Healthcare was infringing upon their mark Letros. Sun Pharma had approached the commercial court requesting for dismissal of the mark Letro by Hetero Healthcare, whereas the commercial court dismissed this application, and Sun Pharma later approached Delhi High Court alleging infringement and passing off against the mark Letro. Sun Pharma sought for a degree of permanent injunction restraining the respondent from using the brand Letro. First, let us look at the commercial court's decision. The commercial court held that the mark Letros by Sun Pharma was not novel, but was merely the first 6 letters of the ingredient letrozole, which is the international non-proprietary name of a salt. So what is INN, or international non-proprietary name? Basically, INN facilitates the identification of pharmaceutical substances or active pharmaceutical ingredients which have been used in the manufacturing of a drug. And this name, which is also known as a generic name, is universally accepted and is also a public property. Hence, the commercial court noted that the word Letros has been derived from the first 6 letters of the ingredient letrozole, which is basically the main component or main ingredient in the manufacturing of this drug. They also noted that the pronunciation of the trademark letro and that of letros was completely different, and there was a structural difference between and a phonetical difference between the two. On the basis of this, and on the basis of the documents produced by Sun Pharma, the court decided there was no prima facie case made out, and hence the application was dismissed. Now, coming to the Delhi High Court's decision, the Delhi High Court bench concurred with this decision of the commercial code, and they too recognized that the word was just derived from the INN letrozole. The court noted that the mark letro is a registered mark of healthcare, and the drugs has been in use since 2007, had created a niche for itself among the public. And also this quoted that the Sun Pharma did not produce any document or evidence to establish confusion among the public because of the mark letro. The most important part of the decision was where the court held the rationale, where it quoted from Sharing Corporation and others versus Alchem Lab, where it said, when the name is derived or coined from the word of a principal ingredient being used in the manufacture of drug, no distinctiveness or exclusiveness can be claimed by the manufacturer. It's very commonly seen under class 5 that the brands that are mostly registered for medicine or pharmaceutical preparations are derived from the name of the active ingredient used to manufacture the said drug. Hence, it is not an innovative or novel thing that is being done. That is why the court very specifically said that when a name is derived or even coined from the principal ingredient being used to manufacture the drug, there is no exclusiveness that can be claimed by the manufacturer. Hence, the court too concurred with the decision and passed an order against the plaintiff. Now, moving on to the copyright updates. Here we'll be seeing the case Neetu Singh and others versus Telegram. Going to the facts of the case, the plaintiff, number one, that is Ms. Neetu Singh, who is an author of various books which are used for competitive exams like UPSC, CDS, etc. So there are two plaintiffs here, basically Ms. Neetu Singh and KD Campus Private Limited, which is an education institution started by Ms. Neetu Singh. They had filed the present suit seeking permanent injunction restraining infringement of copyright in respect of unauthorized dissemination of the plaintiff's video, lectures, books, etc., which was happening via the app Telegram. So Telegram basically is a messaging platform capable of being downloaded on various phones, tablets, computers, and other gadgets, and which enables the transmission of audio files, text files, videos, images, documents, etc. So the plaintiff noted that a lot of private channels had come up on the app, which was supposedly making the plaintiff's lecture videos available and accessible for students at a very highly discounted price. The plaintiff also found that the books of the plaintiffs were being circulated in PDF formats for easy download for for everyone to use. The plaintiff reported this abuse to Telegram, and upon the receipt of the said notice, few channels were taken down by Telegram, but some infringing channels kept cropping up every day with minute changes in the name of the channels which were previously used. So the issue was the plaintiff filed a present suit alleging that the plaintiff's copyrighted work, that is the lectures, the books, the PDFs, and the videos, or all course material, was being disseminated unauthorizedly through the various Telegram channels. So the plaintiff's argument was that as per the privacy policy of Telegram, if there is any violation of law, Telegram is liable to take down these channels and also disclose the information relating to the persons who are running the said channels. Further, while the channels that were reported to Telegram were brought down and taken down, new channels kept cropping up with some different suffix or prefix by making small modifications to the names of the channels, and they continue to be created. Accordingly, plaintiff requested for the identity of the person who was disseminating this infringing material to be disclosed to them so that they can avail all their remedies against the said person. Now, the defense arguments was that the interim arrangement between Telegram and plaintiff, that is where Telegram had already taken down the infringing channels, was enough to protect the interest of the plaintiff. Also, as for the privacy policy of Telegram, until and unless a person is expected to be a terror suspect, the disclosure of the subscriber information could not be made. The defendants also relied on the guidelines stated in the Information Technology Intermediary Guidelines and Digital Media Ethics, which primarily requires the intermediary to only take down, remove, or disable access to the unlawful information. The defendant also placed reliance on the fact that the servers of Telegram are based in Singapore and were highly encrypted. Accordingly, decryption of that data would not be permissible except as per the laws of Singapore. Now, the court here decided in favor of the plaintiffs and directed Telegram to disclose the details of all infringing channels and their owners to be mentioned to the plaintiff. So the plaintiff had submitted a list of channels which were infringing her material on Telegram and had submitted the same to the court. So the court decided that the defendants have to give the information and disclose the information of the owners of those particular channels, and along with any other channels that they may come across who are infringing the plaintiff's copyrighted material. Now, the important aspect here that we need to concentrate is when Telegram claimed that since their servers are based out of Singapore, they do not have to disclose the owners or the group owners' information. The court stated that merely because Telegram chooses to locate its server in Singapore, the same cannot result in the plaintiffs being left completely remedialess against the actual infringers, especially in order to claim damages and avail of legal remedies. So basically, the court stated that just because they choose to place their servers outside of India, they cannot claim that they're not liable under the laws of India, because they have a good client base in India. They have been gaining a lot of premium services from a lot of users in India. Hence, the courts of India are competent enough to pass decisions against them and direct them orders to ensure and protect the rights of a plaintiff. And also the court stated that the dynamic evolution of law is essential to ensure appropriate remedies in case of violation of copyright and other IP laws. Thank you so much. Over to you, Kaju.
Thank you, Lavanya. Next up, we have Aditi, who will also be taking us through a very recent High Court of Delhi judgment, which is Gogoro Incorporated versus Controller of Patents and Designs and another. Over to you, Aditi.
Thank you, Kavya, for the introduction. Wishing everyone a very happy Teachers' Day. So I'll be briefly discussing the case Gogoro Inc. versus the Controller Patents and Designs and another. So briefly the facts of the case as follows. This particular case relates to an appeal challenging the order passed by the Assistant Controller of Patents dated 8th August 2021, rejecting the appellant's patent application for an invention titled Apparatus, Method, an article for authentication, security, and control of power storage devices such as batteries. The appeal was filed under Section 117A of the Patents Act. The particular application was refused on the ground that Section 21J of the Patents Act 1970 had not been complied with. The timeline of the events are as follows. The patent application was filed as a PCT application on 26 July 2012, claiming priority from US patent application, which was dated 26 July 2011. The Indian patent application was subsequently filed on 20th February 2014. A request for examination for the application was filed by the appellant under Rule 24B of the Patent Rules on 30th October 2014, following which an FER was issued by the Patent Office on 20th August 2018, raising grounds of lack of novelty, inventive step, and citing prior art D1 and D2, as well as non-patentability under Section 3K of the Act. A reply to the FER was filed by the appellant on 20th February 2019. Subsequently, a hearing was conducted on 16th December 2020, and the written submissions for the aforementioned hearing were submitted on 31st December 2020 with an amended set of claims were filed with the Patent Office. In the PCT, the Indian application, one of the claim from the PCT application was deleted and the same was filed. Now, in the FER, in D1, some features of D1 were cited, including the method claims, while in D2 only some features were cited and no citation relating to method claims was given in the FER, which means that D1 and D2 did not fairly explain how inventive step or novelty was lacking. Now, 3 issues were raised. There is lack of clarity in the impugned order as to whether the application was rejected on grounds of lack of novelty or whether on grounds of lack of inventive step. The second issue was that 3 prior arts, D1, D2, and D3 were cited in the order. However, the order only discussed D3. Third issue was, which is the issue which I'll be concentrating more on, is lack of reasoning and elaboration on why there is lack of inventive step in the invention in question with respect to the prior art D3. Now coming to the issue 1, rejection on grounds of lack of novelty or inventive step, the court observed that on perusal of the order, it seems that there is a confusion as to whether the application was rejected for lack of novelty or for inventive step. Now, based on the written submissions made before the court and the statement made by the Patent Office, it was made clear that the objection relating to novelty was dropped. And therefore, only the surviving objection in respect to lack of inventive step was there. Now, coming to issue 2, 3 prior arts, D1, D2, and D3 were cited, and only D3 was considered. In regards to that, in the FER, prior arts D1 and D, the court observed that in the FER, prior arts D1 and D2, and the manner in which they support the lack of inventive step is slightly elaborated. Insofar as the impugned order, only prior art seems to have been considered. So in the order against which the appeal was filed, it did not discuss anything about D1 and D2. With regard to issue 3, which is related to lack of reasoning and elaboration on why there is lack of inventive step, the court observed the following, that while arriving at the conclusion that there is lack of inventive step, there is no elaborations or reasons given by the controller for the said finding at all. For the controller to find lack of inventive step, some discussion was required as to how the prior arts render the subject invention obvious to a person skilled in the art. So this point that the controller to find lack of inventive steps, some discussion was required, is an important point which was raised in this particular decision. The court cited its decision in the case of Agribot International LLC versus Deputy Controller of Patents and Designs. And it said that while rejecting an application for lack of inventive step, discussion on prior art, the subject invention, and manner in which the subject invention would be obvious to a person skilled in the art is mandatory. So the word mandatory is important here. And merely arriving at a bare conclusion that the subject invention lacks inventive step would be contrary to section 2(1)(j) of the Act itself. The judgment further cited some of the paragraphs of the aforementioned judgment, and I'll just briefly read the paragraphs which are relevant. In the opinion of this court, while rejecting an invention for lack of inventive step, the controller has to consider 3 elements. First is the invention disclosed in the prior art, the invention disclosed in the application under consideration, and the manner in which subject invention would be obvious to a person skilled in the art. The second important paragraph was, without a discussion on these 3 elements, arriving at a bare conclusion that the subject invention is lacking inventive step would not be permissible unless it is a case where the same is absolutely clear. Section 2(1)(j) of the Act defines inventive step as under. Inventive step means a feature of an invention that involves technical advance. I'm emphasizing on this particular point as compared to the existing knowledge or having economic significance of both, and makes the invention not obvious to a person skilled in the art. So comparing to the existing knowledge and explaining as to why it is not obvious to a person skilled in the art is an important ingredient of section 21JA. Thus, the controller has to analyze as to what is the existing knowledge and how the person skilled in the art would move from the existing knowledge to the subject invention captured in the application under consideration. Without such an analysis, the rejection of the patent application under section 21JA of the Act would be provision itself. Now, discussing the following points for analysis. The controller should provide with adequate reasoning and elaboration on why cited prior art is relevant for rejecting an application for lack of inventive step. It is mandatory to elaborate upon invention disclosed in prior art, the subject invention, and manner in which the subject invention would be obvious to a person skilled in the art. So these three ingredients are important when the controller is providing reasoning as to related to lack of inventive step. Now, if the controller is citing multiple prior arts, then there is a requirement to provide reasoning for lack of inventive step in respect of all the cited prior arts. So in this particular order, only D3 was provided some with some discussion on D3 was given, but it seems from the order that D1 and D2 were also mandatory to be discussed in the order. Application restored to its original position, which means that since the application was at examination stage before the impugned order was passed, after the submission of the amended claims, the application will be re-examined. The use of the phrase may be expeditiously examined by the patent office is permissive and lacks the requirement of obligation, which means that it is not mandatory that the patent office need to examine the application expeditiously. Since the application was filed in 2014, it is possible that again there might be a delay. Now, coming to the last point of analysis, there is no discussion on the point raised by the appellant that the independent method claims are also not considered by the controller, and there is no clarity in the impugned order as to which of the claims lack inventive steps. So, although there were product and process claim, method claims both, the controller mostly discussed on the product claim itself, and there was a lack of explanation regards to method claims, and this particular order is not very elaborative as to what happens for an independent method claim as well. So thank you, everyone.
Thank you very much, Aditi. In fact, this is a judgment that reiterates the fact that the decisions of the patent office have to be reasoned, and especially with respect to inventive step analysis, the decisions have to clearly explain why a particular prior art reference is relevant, how these prior art references when combined would make an invention obvious, and how that obviousness would be from the perspective of a person skilled in the art. More often than not, we see that several decisions that are given by the patent office are quite conclusory, and they lack a reasoned analysis with respect to why an invention is not patentable under a given provision. This case reiterates the need for a reasoned analysis and emphasizes the fact that these decisions can be challenged if they're given in a conclusory manner.
Thank you, sir, for the insights, and thank you, Aditi, for the presentation. Next, we have Sushma, who would be giving us a quick update on patent and design statistics for the month of August.
Thank you, Kavya. Good afternoon, everyone. I'm Sushma from Patents Bioscience Department. I'll be presenting Indian patent and design statistics for the month of August 2022. The graph here represents both patent and design statistics. The colors represents different territorial jurisdictions, starting from Delhi, Mumbai, Chennai, and Kolkata. A total of 4,989 applications were published in the month of August, out of which 1,624 accounts for early publication and 3,365 accounts for ordinary publications. Out of early publications, 614 publications were published from Delhi jurisdiction, 317 from Mumbai, 562 from Chennai, and 131 from Kolkata. Out of 3,365 ordinary publication, 1,380 publications happened from Delhi and 938 from Mumbai, 1,002 from Chennai, and 45 from Kolkata jurisdiction. With respect to patent examinations, a total of 3,857 FERs were issued from Patent Office last month, out of which 1,470 FERs were issued from Delhi, 825 from Mumbai, 1,246 from Chennai, and 316 from Delhi, Kolkata jurisdiction. Last month, 2,295 patents were granted, out of which 809 patent grants were happened from Delhi, 325 from Mumbai, 868 from Chennai, and 293 from Kolkata. Coming to design registration, Design Office has registered total of 499 designs last month. All the data presented here were collected from Indian Patent Office official journal, that is from 31st to 34th issue of August month. For weekly statistics updates, BananaIP provides a weekly statistics update. You can check Intellipedia IP News Center. Thank you.
Thank you, Sushma. Next, we have Nikhil, who will be
We
taking
can
us
see
through-
from the statistics that the Chennai Patent Office has clearly been ahead of the other patent offices in the month of August. It is heartening to see the trend, though. It'll be interesting to watch who does better during the next month.
Thank you, sir. And thank you, Sushma. Next up, we have Nikhil, who will be taking us through the case of Thaler versus Vital, which analyzed whether AI can be an inventor or no. Let's see what the Federal Circuit had to say in this regard.
Hi, everyone. I'll be talking about AI inventorship and most specifically the Thaler versus Vidal recent case by the Federal Circuit. So just as a background, Thaler had filed with the USPTO 2 patent application whose inventor was an AI system known as DABIS. And in both of the patent applications, the AI system DABIS was listed as the sole inventor. And accordingly, with 35 USC 115's requirements, the inventors are supposed to submit a sworn oath or declaration stating that they are the inventor. And since the AI system was incapable of submitting the same, Thaler had submitted a substitute statement on DABIS's behalf. And Thaler had also submitted a document that assigned to himself all of DABIS's rights as an inventor. The USPTO then got back to Thaler stating that both of the applications were rejected because there was no valid inventor mentioned. And accordingly, Thaler had sought judicial review of the USPTO's decision. In the district court affirmed the USPTO's decision stating that the AI system could not be an inventor. In performing this analysis, the district court first looked at what was the definition of an inventor in the Patents Act. And 35 U.S.C. 100 defines an inventor as an individual who invented or discovered the subject matter of the invention. Now, the question then becomes, what constitutes as an individual? And given that the term individual was not defined in the Patents Act, the district court started to define it. And the district court looked at what was the plain meaning of an individual based on the dictionary definition, which stated that it had to be a human being, that is a natural person. And the district court also looked at previous cases that stated that an inventor can only be a natural person. And in the previous Federal Circuit cases that had decided that whether an inventor could only be a natural person, it was done in the context of inventors being a corporation. So while the previous cases didn't directly the issue at hand, which is whether an AI could be an inventor, the previous cases did give some guidance that an inventor can only be a natural person. Nonetheless, Thala had appealed the district court's decision to the Federal Circuit, which brought about the case at hand. So, based on the standard of review, when it comes to statutory interpretation, the Federal Circuit reviews it de novo. And based on their review, they had found that an individual does mean a natural person, and therefore they were in agreement with the USPTO and the district court. So, similar to the analysis that the district court had performed, the Federal Circuit had looked at what was the definition of an inventor as per the Patents Act. And since the term individual was not defined in the Patents Act, they tried to uncover the same. The Federal Circuit looked at a previous Supreme Court decision that defined an individual to be a human being. The case being Mohammed v. Palestinian Authority, 566 United States, 449, 444, and decided in 2012. And the context in which the Supreme Court had decided the case, they looked at whether the term individual was defined as a noun, which was similar to the case in the Patents Act. And the analysis performed by the Supreme Court was the same as the Federal Circuit here as well. Next, the Federal Circuit, in order to define the term individual, looked at how one uses the word individual in everyday usage. And when we use sentences like the individual went to the store, the individual left the room, it is easily clear that the term individual refers to a human being or a natural person. The Federal Circuit also looked at dictionary definitions for the term individual in various dictionaries, such as the Oxford English Dictionary, which defined an individual as a single human being. And 35 U.S.C. 115, which refers to inventors having to submit a declaration or an oath that they are the inventor, that statute had used pronouns such as himself or herself to refer to the inventor. And such kind of pronouns show congressional intent, that Congress intended for the term individual to only mean natural person and not an AI entity. So based on all of this, it is established law so far in the US that an AI system cannot be an inventor. And this is Dabas has the Mr. Thala, who is the inventor of Dabas. He has also filed his patent applications in other jurisdictions, and jurisdictions such as UK and Australia, and along with the US, are in agreement that an AI system cannot be an inventor according to their patent laws. And even though Thala has put forward a lot of policy-based arguments, saying that by the patent office not finding an AI system as an inventor, that they would be going against the principle or their belief of a policy of progression of science, they still feel that the court cannot substitute such policy-based arguments for congressional intent. And it is clear that congressional intent is to be deciphered based on the text of the act that they have put forward. So what we can see so far is that the definition of an individual right now in a lot of the Patents Act, or the definition of inventor, it is limited to just human beings. So if an AI system were to be considered as an inventor, it would be up to the legislatures to accordingly modify the act to broaden the meaning of the term inventor. The second thing is that in this federal circuit case, the issue that was considered is whether an AI system could only be the sole inventor for in an application. And the issue of whether what happens when there is a human inventor along with an AI inventor listed in the patent application is undecided. That's all for now. Thank you.
Nikhil, so far no jurisdiction has held that AI can be an inventor.
So the South Africa patent system has held that an AI system can be an inventor. And in fact, the South African patent system has granted a patent as well. But since the South Africa patent system is a depository system, that is, they just file the patent application, they don't actually examine it for novelty or non-obviousness. And so it's only when during litigation proceedings does such issues arise. However, when it comes to Australia, the lower court, that is the federal court, they had initially found that an AI system could be an inventor because based on their definition of what an inventor was, it wasn't explicitly clear that it excluded AI. But then once it was appealed, the full federal court had reversed the lower court's decision, saying that an AI system could not be an inventor. But this is the law as of now, but it could change in the future.
Okay, so any thoughts about how Indian courts might perceive this?
Yes, so I would say that just like with almost every legal question, the answer would be it depends. Because if you look at Section 6 of the Patents Act, which says persons entitled to apply for a patent application, it says a person who is claiming to be the true and first inventor. And then subsection B says a person who is the assignee of a person claiming to be the true and first inventor. So if you look at the definition of what of a person is based on this, based on Section 6, it could be a human person because they can be the true and first inventor. But a person can also be a corporation because a corporation can be an assignee. So based on this, I would say that the term person can be construed in a broad manner, and so therefore doesn't explicitly exclude AI. Moreover, in the Patents Act, the definition of person, it just says that it includes the government, but it does not explicitly say what exactly what constitutes as a person. So I think based on this, you can interpret or you can make an argument that there is that AI can be considered as an inventor, but the interpretation that would make it that would gear towards AI not being an inventor would be again subsection A of Section 6, which explicitly states that a person claiming to be the true and first inventor. So the key word being claiming. So when you say claiming, there has to be an affirmative act or put out by a person stating that they are the inventor. Now, in Darbus's case, the AI system was unable to put forward such a declaration or oath, because of which Stephen Thaler had to execute a statement on Darbus's behalf. So since Darbus would be unable to claim that, I think that would gear towards a finding that AI cannot be an inventor. So it can go both ways.
So how about an AI system that is capable of explicitly stating that whatever output it is giving could be the potential of a patent application, and the AI explicitly states as a part of that it is claiming to be the inventor of that. So obviously we can design an AI that says that, right? So if it says that, do you think it would fit into the requirement?
So it would satisfy the claiming part of subsection A of Section 6, but again, it would depend on how the courts would define what constitutes as a person. And I am unaware of any Indian case law that has engaged in such an interpretation, but that would be the main issue at hand.
So certain amount of personhood status has been given in India to, for example, companies and certain other body corporates. Similar extension of personhood has also been provided for idols and in other contexts as well. So do you believe that such an approach might be considered by Indian courts, or do you think they will follow whatever other courts are saying?
I think it could be followed by a new approach could be followed by the Indian court that is not aligned with the other jurisdictions. And I think AI is also constantly evolving. Like, I'm not sure if many of you are aware, but I think a month or two ago, there was an ex-Google employee who claimed that an AI system that he was interacting with had become sentient. And of course, those claims were then dismissed, but it is a growing concern for most people that AI is slowly becoming more and more human. And so therefore, maybe then AI may be warranted such a status of being considered as a person. And so I think if Congress or the courts, they want to make things clearer, they would have to come up with a new test or a framework to then differentiate the two.
Okay. And one last question. Do you know if Dabas has filed a patent in India?
No, I don't think so, because from what I recall, it was a PCT application, and I don't think India was listed in as one of those countries there.
All right. Probably we can independently check on the Indian Patent Office website also to cross-check and verify.
Yes.
Okay. Yeah. All right. Thank you, Nikhil. It's very useful.
Thank you, sir. Thank you, Nikhil. Just a second. Yeah, so next up we have Rukaya, who will be substantiating on the Indian patent scenario with respect to Matin of Mesalit post the Novartis judgment. Over to you, Rukaya.
Thank you so much, Kavya. Hello, everyone. Today I will be talking about the challenges encountered by biosciences-based patents in India, and more specifically about the impact of Novartis case on Indian patent scenario. So in India, inventions generated in all fields of technology can be protected by granting the exclusive patent rights to the true owner or inventor, provided all the patentability requirements are fulfilled. So having one's invention patented helps exclude others from making, using, or selling these inventions for the limited period of 20 years. While on one hand, we have these patentability requirements that sort of guarantees patent protection for an invention, but yet on the other hand, we have this sui generis nature of inventions in the field of biosciences, and specifically in pharmaceuticals that often attract various objections due to involvement of life forms. It could, like, such as plants or animals or their parts. Also, because certain subject matters have been excluded from patent protection as per Section 3, which specifies what are not inventions, and Section 4, which specifies inventions relating to atomic energy of the Patents Act 1970. So when it comes to pharmaceutical inventions, they are often challenged under the provisions of Section 3D and 3E, and the provisions of Section 3D and 3D would read as, so the Section 3D, it specifies that the mere discovery of a new form of a known substance, which does not result in the enhancement of the known efficacy of that substance, or the mere discovery of any new property or new use for a known substance, or of the mere use of a known process, machine, or apparatus, unless such known process results in a new product or employs at least one new reactant. Section 3E specifies a substance obtained by a mere admixture resulting only in the aggregation of the properties of the components thereof, or a process for producing such substance. Keeping these laws, these provisions into consideration, about 9 years ago, Novartis AG versus Union of India was decided, wherein Novartis, which is a giant with one of the large international pharmaceutical companies, that had filed an application before Chennai Indian Patent Office for the grant of a patent for an anti-cancer drug, Gleevec, which is a beta-crystalline form of imatinib mesylate. So this application was made in the year 1998. So imatinib, while when they submitted, filed this application, so they had disclosed two methods or two processes of beta-crystalline imatinib mesylate. In one method, they had disclosed that beta-crystalline form of imatinib mesylate could be arrived in 3 steps, wherein the first step would be using an imatinib-free base that would result in alpha form of imatinib mesylate, and which later processes gives rise to beta-crystalline form of imatinib mesylate. While on the other hand, they had disclosed another method in which the beta-crystalline form of imatinib mesylate was arrived at only in one step, which is from the imatinib, using the imatinib free base. In addition to that, Novartis had also claimed some characteristic features of beta-crystalline form of imatinib mesylate, and they had filed these claims, 3 claims basically. One was more beneficial flow properties, another was better thermodynamic stability of beta-crystalline form of imatinib mesylate, and the third claim was that this beta-crystalline form of imatinib mesylate had lower hygroscopicity than the alpha crystal form of imatinib mesylate. So this patent application was made in the year 1998, and it had remained dormant for some years under the mailbox procedure of the patent office. And this application was only taken into consideration in the year 2005. So while this application remained dormant, it had already attracted 5 pre-grant oppositions. And it was in response to these pre-grant oppositions, Novartis had filed the affidavits in which it had submitted a new function, which was bioavailability of beta form of imatinib mesylate to the patent office. So this application was rejected on the grounds of having this product being not novel and not having any inventive step in it. In addition to that, the court also rejected the application on the grounds that the alleged invention was unpatentable under Section 3D of the Patents Act. Because this drug, the said drug, did not exhibit any major changes in therapeutic efficacy over its pre-existing form, which was already patented in a famous patent that came into forefront during the prosecution of this case, which was Zimmerman patent. Then further on, in 2016, Novartis went on to file a petition, 2 petitions actually, in Madras High Court, one challenging the Section 3D, saying that it was unconstitutional, and second petition was filed against the decision that was given by Madras Patent Office. And after that, this Madras High Court transferred this case in 2007 to Intellectual Property Appellant Board, and Appellant Board actually heard the application, heard this appeal, and finally dismissed this application on the basis of Section 3D. And further down the line in 2009, Novartis again went ahead and filed a special leave petition before the Supreme Court of India, challenging the order that was passed by IPAB under Article 136 of Constitution of India. So before Supreme Court could pass judgment, this case was tested on different levels under the provisions of Section 3D. So it was also looked at as to what is a known substance. And then the meaning of efficacy was also examined in a deeper, detailed manner. The affidavit submitting the bioavailability characteristics of enhanced bioavailability characteristics of beta-crystalline form of imatinib mesylate. This was also tested as to whether having a 30% increase in bioavailability would count as an increase in therapeutic efficacy. Also, it was checked whether the invention, which was beta-crystalline form of imatinib mesylate, was more efficacious than the substance that it was derived from. So finally, Supreme Court, as it was famous because this case caught a lot of attention, it created a lot of ripples. So this case was finally rejected by Supreme Court on the basis that the substance imatinib mesylate was already known, and the beta crystalline form of imatinib mesylate was a new form of the same substance. And the efficacy of imatinib mesylate was already known, and Novartis did not provide any supporting documents that could show that the efficacy of beta crystalline form of imatinib mesylate was more than the original imatinib mesylate. So in addition to that, court also made it clear that none of the properties as claimed by Novartis, that is flow properties, better thermodynamic stability, and lower hygroscopicity, it did not contribute to increase in therapeutic efficacy. So this Supreme Court judgment was actually really beneficial in two ways. One was because it prevented the evergreening of patented products. Section 3D of Patents Act 1970 prevents by obtaining secondary patents by just, there are inventors who would just come up with a new form of some known substance and claim that it has got enhanced efficacy, like Novartis did in case of beta crystalline form of imatinib mesylate. But they were not able to provide any data that would support their claim. So in order to prevent such secondary patents, this Novartis judgment that was passed by Supreme Court was really helpful. So another thing was to give relief to those who cannot afford the life-saving drug, as these pharmaceutical companies, large pharmaceutical companies, they sell such life-saving drugs at a very high price, hence which becomes eventually unaffordable for the common man. Supreme Court in its judgment made clear that India is a developing country and the availability of medicines at a cheaper rate is necessary for the lives of 1 billion people. So I would also like to add here that while this Novartis case was being decided, they had applied for exclusive marketing license. They had so they had they had applied for exclusive marketing privileges for the same drug, which was Gleevec, and it was filed in 2002, and the same was granted to them in 2003. So it was brought to the Supreme Court's notice while this case was being heard that when the appellant was holding the right as exclusive marketing right on Gleevec, it used to charge rupees 1,20,000 per month for a required dose of the drug from a cancer patient, which was not disputed by the appellant. Which in our view is too unaffordable to the poor cancer patients in India. That's what Supreme Court said. And further, Supreme Court went on adding that we also observe that a grant of product patent on this application can create a havoc to the lives of poor people and their families affected with the cancer for which this drug is effective. This will have disastrous effect on the society as well. So based on the laws and this the judgment of Novartis case in 2013, so we wanted to take a look at the impact of this judgment on the pharmaceutical patent filings in India. Yeah. So a comprehensive search was conducted looking at the patents that were filed in India using InPass, which is an Indian Patent Office search engine, which gives access to all the patents that were filed in India. So if we take a look at this graph over here, it was observed that many patents from the year 2013 and 2022 were filed. Every year, on an average, about 75 patents were filed from the period of 2013 and 2022. And in all the patent applications pertaining to pharmaceutical molecules, it was observed that about 1,328 applications were filed. So we wanted to take a further look at these applications as to what the nature or what the status of these applications was. It was further observed that out of these, all these applications that were filed from 2013 and 2022, about 1,135 patent applications were published and 193 patents were granted. So of all these 193 patents that were granted, these patent applications related to different categories, which is antibodies related to biochemicals, related to diagnostic methods, markers, nanoparticles, new chemical entities, organic components, and peptides and process-based patents. So it's quite interesting to note over here is that the major portion of these patents that were granted were in the category of new chemical entities. So further, we were curious to understand as to how the scenario of imatinib-based or imatinib mesylate-based patent filing looked like. So we analyzed the data taken or retrieved from InPass. It was observed that about 24 patents were filed in which imatinib or imatinib mesylate was disclosed, or some different forms of imatinib or imatinib mesylate were used. Out of these 24 patents, 22 were published and 2 patents were granted. And of these 2 patents that were granted, one was granted in 2013, and the title of this patent is Preparation Method of Alpha Imatinib Mesylate. And another patent was granted in 2017. And this patent, the title is Preparation and Evaluation of Nanoparticles Containing Imatinib Mesylate and the Complex of Imatinib Mesylate Cobalt 2nd Chloride. So both these patents were objected on the basis of Section 3D, but during their prosecution stage, these applicants were able to overcome all the objections, wherein they showed that the preparation method, or in the case of complex of imatinib mesylate cobalt 2nd chloride, they were able to show that these are new, fairly new applications or fairly new inventions. Therefore, these patents were granted. So we further went ahead, and it was quite interesting to see how Novartis was doing when it came to filing pharmaceutical-based inventions in India. Since Novartis received its first rejection in 2005 So we wanted to analyze as to how the trend of filing for such molecules in India went. So we analyzed all the files. All the applications that were filed by Novartis in India from the period of 2005 to 2022. It was observed that Novartis kept filing for applications which were related to pharmaceutical-based molecules. So the applications filed in 2008 were maximum, which was about 50 plus applications, followed by 2009, and which was further followed by 2007. So no applications were filed by Novartis from 2018 to 2022. So in total, Novartis had filed about 177 patents from the year 2005 to 2022. So further, it was observed that the nature of these applications that were filed by Novartis belonged to different categories, in which one category was of the patents that had antibodies disclosed in them, and device-based. One particular application which mentioned F, G, H, I, and K crystal forms of imatinib mesylate, which was filed by Novartis. And some applications were filed that had markers disclosed in them, and some of them had new chemical entities that had new chemical entities mentioned in them, and organic composition based and treatment method based patents were also filed by Novartis. So of all these patents, the major portion of the patents that were filed by Novartis were in the category of new chemical entities. And so the important patent that was filed by Novartis, which was FGHI and K crystal form of imatinib mesylate. So it was further interesting to figure out as to what was the fate of this particular application that was filed in 2008. So it was observed that this patent stands abandoned under section 21(1). Further, we wanted to see of all these patents that Novartis had filed, how many patents were granted. So Novartis has received about 4 patent grants in the year 2006, 3 grants in the year 2007 and 8, and 2 grants in 2009. And 3 grants in 2010, and 1 grant in 2012, and 2 grants in 2015. From 2016 to 2022, Novartis has not received any patent, has not been issued any grants on any of the patents. So in total, 18 patent grants have been received by Novartis from the year 2005 and 2022. Patenting of pharmaceutical inventions in India is still in its infancy, and more patent files wherein new forms of chemicals or new forms of substances of already existing chemicals would be filed, and wherein all the supporting data would also be submitted. It's yet to be seen as to what kind of a fate those applications would face. So yeah, so it would be really amazing and interesting to keep a watch on this. Yeah. Thank you.
So Rokaya, one question. Out of the 1,000 odd patents that were filed in India, have you gotten an opportunity to check how many of those applications were examined and how many 3D objections were raised?
Sorry, how many applications were examined?
And how many of them had 3D based objections?
3D based objections.
Yes.
So maximum number of these, I mean, I don't have a particular number, but maximum number of applications that I took a look at personally had 3D based objections in them, had received 3D based objections, but I don't have a number as of now I mean, the
Okay,
exact
is
number.
3D raised even for new chemical entities as a matter of fact by the patent office, or new chemical entities, they normally don't raise it?
No. For new chemical, for the patents that disclose new chemical entities, they did not have any objections on the basis of Section 3D. Yeah.
Okay, and would you say that based on the filings of Novartis you looked at, they changed their filing strategy with respect to what they would file after the Supreme Court judgment in 2013?
It might look like that because I particularly took a closer look at this imatinib application, which was filed in 2008, which had disclosed about FGHI forms of imatinib mesylate. So it has been abandoned. Maybe, I mean, they could be strategizing some new ways of filing for those forms of.
Okay, you mean to say it was abandoned after 2013?
Because it was filed in 2008 and they received their first objection or rejection in 2005. So that
2015, you would say 2015 maybe.
Sorry.
The first objection was received in FER was received in 2015. Is that so?
No, 2005, because this application was taken into consideration for the first time in 2005, and Novartis had applied the Novartis case that was decided in 2013. So this application had actually been filed in 1998, and Novartis received its first objection in 2005.
No. With respect to the FHK crystalline form, is that what you're talking about?
So yeah. So crystalline form of
Okay.
other forms of imatinib were filed in 2000.
No. Okay, anyway, that's fine. I mean, I think we can discuss this separately. But what I was curious to know is, one was the 2008 application examined. That is fine. It's all right. We'll talk about this later.
Okay.
Yeah.
Thank you.
Thanks.
Thank
In
you,
fact,
sir.
that's quite insightful.
Yes, sir.
Sorry, Kavya.
No problem.
That's quite insightful because I think Novartis case emphasized the need for data to support enhanced efficacy with respect to new forms of known substances, which in other words means if you're filing a new form of a new chemical entity, then you will have to submit data along with your application to show that there is enhanced efficacy. So this case has set that principle straight by saying that with respect to each application that relates to a new form, the enhanced efficacy would relate to the purpose of that particular substance. In other words, in this case, because it is meant for therapy, then enhanced efficacy would mean therapeutic efficacy. So, yeah. All right. Yeah. Thank you. Yeah.
Thank you, sir. Thank you, Rukaya. So we received a comment requesting for the PPTs for reference. We would like to inform you that please feel free to drop us a mail on contact@bananaip.com requesting for the PPT, and we'll be happy to share them with you for reference. Thank you. Next up, we have Naika, who would be taking us through the GI polls published by the Indian Patent Office as a part of its National IP Awards initiative. Over to you, Naika.
Thank you, Kavya. So the Office of Controller General of Patent, Designs and Trademark have issued a GI poll, whereas public at large can cast their vote on which is their favorite or which is the interesting GI for them. It's a good initiative by the Office of CGPDT, where they are also creating awareness of different type of GIs and also encouraging through this process to get other applications of GI throughout the country. So they have divided in all the GIs in 5 different categories. One will be the agriculture, foodstuff, handicraft, manufactured, and the natural GIs. The first one is agriculture. So in this category,
all the products which are available in the nature, or we can say are cultivated through and are special because of the climatic conditions they are getting. They are under the agriculture sector. So few of the examples I have tried to bring out to you. That first one, if you can see first, is the Darjeeling tea leaf. It's showing that Darjeeling tea. The Darjeeling tea was the first application which was filed in the GI registry to obtain the GI and the geographical indication. It's found in the Darjeeling, and it has a very refreshing taste. All the tea lovers would be knowing what the Darjeeling tea is, and if no, then please go and please have a taste of the Darjeeling tea. The second one in the line is Kamrapur Red Banana. Before going to Kamrapur Red Banana, I would like to say that I was amazed that there were 7 to 8 type of GI already filed for bananas. There are different type of bananas available, and we being BananaIP, in our office, we did a poll that which is their favorite banana, and it was amazing to know that Nanjangud banana, which is found in Nanjangud area of Karnataka, came out to be the favorite of our BananaIP peoples. Coming back to the Kamrapur Red Banana, this is found in Hulimau district of Karnataka, and this is red in color and has a very sweet and creamy texture of the pulp, which is also used by, also recommended by the doctors for typhoid patients, particularly for the children. In the next, we have Alfonso mango. This mango are found in Ratnagiri, Maharashtra district. These are known for their sweet pulp and sweet texture without any fibers, and they have also a firm pulp in it. It doesn't have liquidy pulp. This is known for even exporting the mangoes, whichever is, it's the best in exports. The fourth one in line is Hadigali jasmine. So this is known for its fragrance, jasmine fragrance, and it is mostly used in garlands, decorative stuff, and also it's also a part. It's also cultivated in the Huvina district of Karnataka. The fifth one is Elliptic green cardamom. This cardamom is known as the king among all the cardamoms, and it is known for the for its three curved ribbed appearance. It is 7 mm in size. It's found in Tamil Nadu and Karnataka district of India. The last one is Mizo chili, that is found in Mizoram. It is one of the spiciest chilies present in India. It's also known as bird eye chili, and when it didn't attain the GI application, GI registration, it was sold up to 150 or till 300 per kg. After it attained its GI registration, it is sold at 3,000 per kg as red powder. Now going to foodstuff is the product which are made specifically by a region-based people, which is known specifically. The recipe is known specifically to that region. For example, Ratlami sev, Tirupati laddu, or in that case there is Kovalapatti kadlai mithai, which is also known as the peanut candy. Ratlami sev is made out of besan and have a spiciness of pepper in it, and it's known for its spiciness. It's made in Ratlam area of Madhya Pradesh. The second one is Tirupati laddu. It's found in Andhra Pradesh, and it's given as a prasad form in the Tirupati laddu. Its recipe is very pious, and they have tried to treasure the recipe and have applied for the GI have applied for the geographical indication, and they have also got the registration. The last one, which is the Kovalapatti Katlai Mithai, is type of a groundnut
groundnut or peanut candy, which is also known as chicky and other things in different places of India. But the best, specific or unique characteristic of this mithai is that it is made out of two types of jaggery with the groundnuts in it, and the when the jaggery is melted together, two types of jaggery is melted together, that syrup is their secret, and that's why it's special in Tamil Nadu. The third sector is handicraft. Handicraft is also again the knowledge of region-based people, like a different specific type of region, a specific culture, which it tries to emboss upon. The five examples I can portray here is Madhubani Painting, which is from Bihar. It was initially started by the Mithila region women. They tried painting the Madhubani painting on their house wall. Later on, it was so famous that people started making a frame out of it, and then they started bringing that to the urban areas also. It's very famous for its depiction of social scenes, religious scenes, or elements of nature. The second one is the Konark stone carving. Konark stone carving is very minute stone carving, which the artisans carve stone in the form of a god, goddesses, or even they try to show the culture of different ages. We can see the stone carving on temples, different temples available throughout India. The third one, the photo is of agates of Kembe. The agates of Kembe are stones. It is also known as akik in different regions of India. The akik is used in jewelry making, or even pendants of different sizes. So the akik, which is mined, and then it is polished, and then it is converted into it's put in a jewelry. Akik is found in Gujarat, Anand area, and it has its relevance from 15th and 16th century. The fourth one is brass broidered coconut shell craft. This is a craft. This is craft of Kerala. In Kerala, usually they don't throw away the coconut after optimally using whole coconut, the water, the shell inside it, everything. They even use the shell of a coconut by carving the designs or painting on it, and they use them as showpiece, or even they use the coconut shell as Malabar hookahs. It's also known as Malabar hookahs in that area. This is found in Kozhikode district of Kerala. I also was scrolling through internet of finding this brass coconut shell craft for myself, and I found a teapot which was having a coconut shell designed with a coconut shell on it. The fifth one is blue pottery of Jaipur. This is famous for pottery all across India. We can find it in Jaipur. The blue color in it is due to cobalt oxide, and it's majorly found in Jaipur, and the design over it is of flower or Persian or any Persian design or motifs like peacock or elephant, etc. Then the fourth category is manufactured. So all the products which are manufactured in different regions of India are under this category. Some of the examples I like to bring in is Dindigul locks, then Kaju Feni, Mysore sandal soap, Meerut Caesar, and Nashik Valley's wine. So this if we start with Dindigul locks, then it is made in Dindigul area of Tamil Nadu, which is famous for its safety, design, quality of the raw material they are using in it. Even they have 50 types of design in a lock, and their motto, the motto of the association is, "Our customer are trustful and thieves are fearful." So it was very amazing to know how much people trust this lock and how much even efforts they put in bringing the logs to be of good quality. Second is Meerut Caesar. Meerut Caesar is found from Meerut, is manufactured in Meerut, and it was great to know that 50,000 people are directly involved in the manufacturing process of Meerut Caesars, whereas 20,000 people are indirectly involved in manufacturing or even the exporting process of the Meerut Caesars. They are known for its very cut edge sharp, very sharp edge, which is used in any barber scissor or cloth scissor, etc. The third one is Mysore sandal soap. Mysore sandal soap is a very old soap, which is used, I guess, by generations and generations. They are known for its first the oval shape, which they have, and the ochre color which they have on this soap. It's made up of 80% of biodegradable veg oil soap, which is blended very well with the sandal soap oil, which gives the fragrance of the sandal soap. And it is packed in a traditional box, which makes it look very fancy. And I'm sure that every home, like you in your lifetime, you would have definitely come across the sandal soap once. The fourth one is the Kaju Feni. Feni is a famous product in Goa. It is manufactured in Goa through fermenting and diluting the cashew plant by the diluting cashew plant, and they box it in a, they put it in a what we say, the glass bottle, so that it stops the fermenting process. They have various factories and distilleries of the Feni bottles over there. And the last one is Nasik Valley wine, which is again very famous in Maharashtra, Nasik area. Nasik is known for its wine. It is because the unique climatic condition the grapes over there they get, it adds to the tropical flavor has been added to the wine over there, which gives a different taste to the Nasik wine than other wines. And the last one is the natural. The natural includes all the products which are available in nature, and we use it in the present form, and it may be used in construction or artifacts. For here I am giving two examples, that is Makrana marble and the Chunar Patthar. Makrana marble are found in Rajasthan, and it is a marble which is the hardest form present if we compare it to Greece and Italy. And 98% of the marble is made up of calcium carbonate, which gives it a shine, which other marbles don't get. They are artificially added into the marble. And the second example is for Chunar Patthar. It is found in the Chunar region, which is placed in Vindhya ranges. And the places like Mirzapur, Chandauli, and Songarh are famous for the Chunar sandstone, which is exclusively found over there. You can also vote for any GI if you find it interesting. Even you can go through the website, through the GI poll. I'll send the link in the comment box. Thank you.
Thank you, Naika. So if anyone's interested in voting for their favorite GI, please feel free to click on the link given in the comments for the live. Also, the Office of CGPTM has extended the last date for receiving applications for National IP Awards to 10th September. Naika.
Naika, I have a question. Any idea of which one of these is leading? Does the patent office display the results?
No, sir. Patent office is not displaying the results. The poll is going to end on 2nd October. I guess after that only they'll for one give the results out.
All right. Okay. All right. Thank you.
Thank you, sir. And with that, we come to the end of this month's Text in Context with BananaIP. And I would like to thank all of you who joined us this evening. I also extend my gratitude to all the associates who took our time to provide the text with some insightful context. If you want us to cover some specific topics for our next edition, please feel free to drop us a comment on the LinkedIn Live or write to us at contact@bananaip.com. Along with conducting text in context regularly, we also, I would like to take this opportunity to inform you all about that we have IP for business value video series being published on our LinkedIn page regularly. And with that, we come to the end. See you all for the next Text in Context with BananaIP. Until then,